Hello friends, welcome to Analytics IS Academy and our YouTube channel Let's Crack IS Analytics IS. My name is Pankaj Shukla, and as we have already discussed that we have been running a crash course targeting UPSC CSC Prelims 2020, in which we are doing a series of lectures targeting your prelims examination for your better understanding, for your better knowledge. And in these series of lectures, especially in polity section, I have already covered certain important aspect of Indian constitution, in which I have already covered constitutional historical evolution of Indian constitution. Then we discuss about preamble, citizenship, fundamental right, directive principle of state policy, and fundamental duties. After that, friends, I started with you people another important aspect of Indian constitution, from where UPSC has asked questions in last previous year repeatedly. That is one chapter of President of India, and because of the voluminous nature of this particular chapter, this particular part of Indian constitution, we are taking it in two sessions of 1 hour each. In last session that I discussed with you people, we tried to understand that why we need President of India in a parliamentary form of democracy that we adopted in case of India. Then we also tried to understand how this position of president evolved in last 70 years, from 1950 till 2020. Then we tried to understand how president of India get elected, why we have followed proportional representation system and not first past the post system, why there is a system of indirect election and not direct election. All these ideas we have discussed. We understood the electoral college of president. Then friends, we also discussed the idea about impeachment of president, then on which ground president of India can be impeached. And there we discuss article 61 of Indian constitution, where we discuss that on the violation, on the ground of violation of constitutional provision, we can impeach president of India. And both the houses of legislature in case of India, they were participating in that impeachment process. Then we discuss a certain essential qualification for contesting the election of president, disputes related to election of president. All these matters we have discussed related to office of the president or position of the president. We try to explain as per constitutional dignitaries like Dr. Ambedkar, that what kind of the position of president our constitution makers they wanted to create. There we also discuss a debate between constitutionalists and liberals. So if you have missed these lectures, if you missed the last lecture about president, so please go through our playlist and try to see, because from that particular area, many times UPSC and state public service commissions, they have asked question. So in this particular session, friends, we are going to discuss about various powers of president of India. We will discuss veto power of president. We will discuss other executive power of president. We will discuss ordinance making power of president, and we will also discuss clemency power of president, judicial power of president, which can be important from this year prelims perspective, considering one famous case of Nirbhaya, where those who were acquitted, those who got convicted, they use this kind of opportunity that they appealed repeatedly for clemency petition, then the curative petition. Such things were there in news. So those convicted people, they were trying to use these provisions which are present in our constitution. So from this perspective, I am saying that judicial power or that clemency power can be one important area from this year prelims point of view, even though I am not predicting anything. But since these things were there in news, and because of that, from this year prelims perspective, they may be one important area from where UPSC may ask question. Having said so, now I will start with veto power of president. So first we will try to understand, friends, why there is any veto power, why president of India is equipped with such kind of power which is known as veto power of president. So हमने आपके साथ डिस्कस किया in previous classes that there is a kind of separation of power where legislature's prerogative is to enact law, judiciary's responsibility is to look into the constitutionality of such law and part of executive that have been given power, that is to execute or implement these laws. But mostly what happens, that we discuss that in kind of parliamentary democracy that we have, the government is enjoying majority in Lok Sabha, and many a times they also enjoy majority in Rajya Sabha also. That may not be the case always, but many times it happens that party ruling at center, they enjoy majority in Lok Sabha as well as they enjoy majority in Rajya Sabha. So in such scenario, these legislations, they are initiated by these Council of Ministers. And Council of Ministers, friend, we have already discussed. It is nothing but it is a group of political people coming from a particular party. They were voted to power, and whenever they try to bring legislations, these legislations are in general public interest, but there may be a kind of occasion, there might be certain situations where these legislations that are being enacted by legislature, they are purely because of some political consideration, some because of political consideration, some politics is involved, certain sections that they are targeting who may get benefit from such kind of legislation. In such cases, there should be someone, there should be some neutral body like president who has taken oath in the name of preserving, protecting and defending Indian constitution, where he may prevent such legislations from being an act or a kind of law, and they will ask legislature that they should reconsider, saying that this particular bill that may not be as per parameters of what constitution, or this particular bill or this particular legislative proposal that may not be in larger public interest, and for that purpose veto power has been conferred to Indian President under Article 111 of Indian Constitution. So whatever is there in Indian Constitution, you should be very clear that why it is there as it is there. So you should know the rationale, you should know the logic behind such kind of powers, that why Indian President has been equipped with such veto power, just to prevent such hasty legislations, just to prevent legislations which may not be in general public interest, or to prevent such legislation temporarily which may be against the parameters of what constitution. For that purpose such check is there with President of India, where he may exercise his veto power. So under Indian Constitution, any bill, any legislative proposal which has been passed by both the houses of parliament, when it goes to President of India has four options, and these options are mentioned in Indian Constitution. Either he may give his assent to bill, then such bill will become an act, or he simply withhold assent, he may reject giving his assent, then that will be known as absolute veto. Then he may send this bill for one more reconsideration of parliament with some specific reasons or otherwise, that will be known as suspensive veto. And the fourth is that president does not take any action on such legislative proposal, and that will be known as pocket veto. So as such, Indian president enjoys three such veto: suspensive veto, absolute veto, even though it will be limited, later on we will discuss in detail, and third one I am saying pocket veto. One by one I will try to explain you, but while explaining veto power of Indian president, for your better understanding, for your better knowledge, on your screen you may find a kind of comparison between veto power of US president and veto power of Indian president. So in US there is a kind of presidential form of government, and there president is a head of the state as well as head of the government. So he is a real executive president. But in case of India, friends, we have already discussed that India adopted a parliamentary form of government, and in parliamentary form of government, head of the state is not the head of government. President is head of the state, he is not the head of government. So he is enjoying veto powers under Indian Constitution, but his veto powers that may be not as powerful as in case of US president. That we will try to compare. That US president enjoys four kinds of veto. First veto is absolute veto, where he may withhold assent to the bill. Second type of veto is suspensive veto, where he is sending bill for one more reconsideration of Congress. In US, both the houses of legislature in combination, they are known as Congress. Third is pocket veto, which is limited in case of US president, because whenever any bill in case of US president or US constitution is presented before president, within 10 days he has to give his intent, yes, no, or whatever he want to say, he has to mention his intent. So generally in case of US, pocket veto is limited only for a period of 10 days. In certain cases it may go beyond 10 days also, that I will discuss right now. And then last one is qualified veto, where on certain part of the bill, certain provisions of the bill, president wants to exercise veto power. In comparison to these four veto power of US president, friends, you will find that Indian president enjoys three veto power: absolute veto, suspensive veto, and pocket veto. US president four types of veto power. Indian president, I am saying three types of veto power. In case of US president, I am saying that if he is exercising suspensive veto, if he is sending back that legislation to both the houses of parliament, or what I am saying Congress, then Congress can override those objections which were raised by US president by simple majority. They can again send back the same bill even without any modification. And in case of qualified veto, if US president has raised certain objections on certain provisions of bill and send back it to the both the houses of parliament, being referred as Congress, US Congress, so US Congress can override those objections by a 2/3 majority, and they may send back that bill without any modification. So this thing you have to keep in your mind, that in case of ordinary suspensive veto, legislature in case of US, they are overriding by a simple majority. In case of qualified veto, legislature in case of US, they are overriding with a special majority of 2/3 members. On the other hand, in case of Indian president, I am saying if US president exercise absolute veto, then that bill cannot become an act, because in US president is enjoying real executive power. But in India, since Indian president is not the real executive president, largely he act on the advice of Union Council of Ministers, that we have already discussed in the last class. So in case of Indian president, he can exercise absolute veto only on the advice of what? Union cabinet. And when he will advise, when previous government, just before completion of its term, previous legislature, just before its completion of term, they have enacted certain financial legislations whose burden will be on exchequer. So after new government comes into picture, they assumes their office, they may give advice to president to exercise veto on such bill, such legislations whose burden will be on the new government. So new government, they may send advice to the president to exercise veto power on such bill which were proposed by outgoing council of minister, outgoing legislature, just before completion of their term. So friends, that you have to keep in your mind, that only in such cases Indian president can exercise absolute veto, just to prevent financial legislations by outgoing legislature, whose burden is going to, whose impact is going to on new house or new council of minister. So the new council of minister is advising president not to go further, not to give his assent. That kind of the absolute veto can be there with Indian president on the advice of what? Union Council of Minister. And second, Indian president can exercise absolute veto in case of private member bill. A member of parliament who is not member of Council of Minister, on such bills Indian president can exercise absolute veto. Otherwise he has a limited power in case of veto, or especially in case of absolute veto. On these two conditions he can exercise, in these two situations he may exercise absolute veto. So I hope this ये idea आपके mind में clear हो रहा होगा कि US president can exercise absolute veto and then such bill will not be able to become an act. But in case of Indian president, he can exercise absolute veto only on the advice of cabinet or in case of a private member bill. Then Indian president can also send back that bill for one more reconsideration of parliament. So he is sending bill for one more reconsideration of parliament. But after such reconsideration, if parliament sends back that bill without taking into consideration the objections raised by Indian president, so they require only ordinary majority. With ordinary majority, they can override those objections, those suggestions which were raised by president. So here it is similar to that of US president, that you may see through your screen, that in case of suspensive veto, a legislature can override a presidential objection by an ordinary majority, but such suspensive veto cannot be exercised in case of a money bill. That you have to keep in your mind. Why, friends? Because money bill was introduced on the recommendation of president only. So with your prior recommendation only, money bill was introduced on the floor of parliament, and when both the houses of parliament they have passed, then president is not supposed to exercise such suspensive veto over money bill. In case of pocket veto, you will find Indian president and his pocket veto power is wider than that of US president. In case of US, we have discussed that within 10 days he has to express his intent on any such legislative proposal. Only in certain extraordinary case, when Congress is not in session, then only that may go beyond 10 days. Suppose bill was received by president and within next 3 days house got urgent or prorogued, then that pocket veto may extend beyond 10 days. Otherwise, in case of US, within 10 days US president has to express his intent. But here, in case of Indian president, constitution nowhere defines, nowhere prescribe any time limit within which Indian president has to give his opinion, and because of that here pocket veto you may extend carry for your entire term. पूरे 5 साल के लिए भी आप पॉकेट वीटो क्या कर सकते हैं, एक्सरसाइज कर सकते हैं. बट नो सच पॉकेट वीटो ऑन कॉन्स्टिट्यूशनल अमेंडमेंट बिल. सो 24th Constitutional Amendment Act, President has to give his approval on Constitutional Amendment Bill. And in case of money bill, we have already discussed that no suspensive veto, anything that President can exercise, that is only pocket veto. So this thing you have to keep in your mind, that it was President Gyani Jail Singh, our former President, who exercised pocket veto in case of Postal Amendment Bill. So that was one example where you are exercising pocket veto for entire term of President. Then presidential power to veto also extend on those bills which were passed by state legislature, either state legislative assembly or in certain cases where council is also there. So under Article 200, later on also we will discuss while discussing governors of a state, they can reserve certain categories of bill for reconsideration of what? President. And any such bill which has been referred by governor for reconsideration of president, while reconsidering, president can either give his approval, or he may reject that bill, or he may return it for reconsideration. But that return, that cannot be in case of money bill. In case of money bill, President of India cannot send it for reconsideration. That thing you have to keep in mind. That is one important fact that you have to keep in mind, कि राज्यों की जो विधानसभाओं द्वारा पारित किया गया बिल है, जब ये प्रेसिडेंट के पास जा रहा है तो वहाँ पे प्रेसिडेंट या तो उसे अपना अप्रूवल दे सकते हैं, रिजेक्ट कर सकते हैं, या रिकंसिडरेशन के लिए भेज सकते हैं. बट रिकंसिडरेशन के लिए ही कैन सेंड ओनली ऑर्डिनरी बिल फॉर रिकंसिडरेशन. ही कैन नॉट सेंड बैक money bill passed by state legislature. So these are certain limitations, these are certain important fact related to veto power of president. So whatever questions will come in examination, through this knowledge probably you will be able to solve. So in brief, or in detail you may say, I tried to give you each and every aspect related to veto power of president. And now I will start one another important aspect related to presidential power, that is ordinance making power of president. So friends, in modern day democracy, you will find that it is legislature that makes law, and when legislature they make law, any such legislative proposal, it goes through a kind of elaborate process, detailed debate, discussion, deliberation over such bill. Many time it happens that parliament may not be in session. So for your understanding, I have mentioned that you may see that generally Indian Parliament meets in three regular sessions: budget session, monsoon session, and winter session. There can be some special session also in order to transact some special legislative business when convened by President. But there might be some situation because governance is not something that on some days you are doing, other days you are not doing. But parliamentary sessions, they are taking place on certain month, they may not take place every day, but governance take place every day. And in that process there might be a need for immediate legislation, and ordinance is nothing. Ordinance is such immediate law making power of what? Executive. So ordinance making power means immediate law making power of executive when one or both the houses of parliament they are not in session. And if president is satisfied means on the advice of Union Council of Ministers that there exists an immediate need for bringing a new legislation. For example, recently हमने ये पाया कि during such corona epidemic disease there were instances when doctors, or whom we were calling corona warriors, they were being attacked by crowds in certain areas. So these doctors who were working day and night, they felt themselves insecure, and because of that their body, Indian Medical Association, they threatened that we need protections, then only probably we will be able to discharge our duties in a responsible manner. And because of that, immediately, since there was a need that doctors they should work in such crisis situation which we were referring as like health emergency situation, epidemic disease amendment ordinance 2020 was introduced by president on the advice of whom? Union Council of Ministers. So here I am saying when one or both the houses of parliament they are not in session, and when there is an immediate need for one such immediate law, then under article 123 president of India can promulgate an ordinance. Any such ordinance promulgated by president, it will have same effect as law enacted by Union Parliament. So president द्वारा promulgate किया गया ordinance का effect same होगा, वैसा ही होगा जैसा किसी ordinary law का होता है, जैसे parliament enact करते हैं. But any such ordinance shall cease to be in force on expiry of 6 weeks from reassembly of both the houses of parliament unless it is approved by parliament. ऐसा कोई भी ordinance पार्लियामेंट की रीअसेंबली के 6 वीक के अंदर पार्लियामेंट के फ्लोर पे रखा जाएगा, और अगर पार्लियामेंट ने इसे अप्रूव कर दिया, अपना अप्रूवल दे दिया, देन इट विल बिकम ए रेगुलर लॉ. अदरवाइज इफ एन ऑर्डिनेंस विल बी अलाउड टू लैप्स विदाउट बीइंग प्लेस्ड ऑन द फ्लोर ऑफ पार्लियामेंट, एंड इन दैट प्रोसेस 6 वीक का टाइम पास हो गया, देन ऑल दोज एक्ट्स which were completed in the name of such lapse ordinance, they shall remain valid. So इस बात को आप समझने की कोशिश करिए. प्रेसिडेंट द्वारा लाया गया कोई भी ऑर्डिनेंस, इसे हमें अप्रूव कराना है बोथ द हाउसेज ऑफ पार्लियामेंट से विद इन 6 वीक फ्रॉम रीअसेंबली ऑफ बोथ द हाउसेज ऑफ पार्लियामेंट. अगर बोथ द हाउसेज ऑफ पार्लियामेंट में 6 वीक के अंदर ये रखा गया और अप्रूव हो गया, नाउ इट विल बिकम ए रेगुलर लॉ. बट अगर ये अप्रूव नहीं हुआ, then ordinance will lapse. What if एग्जीक्यूटिव ने इसे पार्लियामेंट के फ्लोर पर रखा ही नहीं और इस पूरे प्रोसेस में 6 वीक का टाइम भी पास हो गया, then legally that ordinance stands lapse. But all those actions that have been already initiated and completed in the name of such lapse ordinance, they will remain valid. सो पार्लियामेंट के 2 सेशन के बीच में जो मैक्सिमम टाइम लिमिट हो सकता है दैट इज फॉर 6 मंथ, एंड आफ्टर रीअसेंबली यू ऑल्सो हैव 6 वीक. सो मैक्सिमम टाइम पीरियड फॉर विच एन ऑर्डिनेंस शैल रिमेन इन फोर्स without being approved by both the houses of parliament, that time period can be 6 month plus 6 week. This thing you have to keep in your mind that maximum time period जिसमें ऑर्डिनेंस इन फोर्स में रह सकता है बिना अप्रूव या डिसअप्रूव हुए बोथ द हाउसेज ऑफ पार्लियामेंट से, दैट टाइम पीरियड इज 6 month plus 6 week, and any such ordinance can be withdrawn at any point of time by president. There are some important facts related with ordinance that I have mentioned here. That origin of this ordinance making power you can trace from Government of India Act 1935. So जब मैं आपके साथ historical evolution of Indian Constitution discuss कर रहा था, there I discuss with you people that ordinance making power was introduced in this particular act. And when I am saying president is promulgating an ordinance, don't think it as president in his personal discretion is doing it. President is promulgating an ordinance on the advice of Union Council of Ministers, and such ordinance making power of president is not immune from judicial scrutiny. Judiciary can scrutinize, judiciary can review ordinance making power of president on the ground of misuse of power, on the ground of mala fide use of power. So such power of president is not outside the power of judicial review, and it cannot be used to amend Indian Constitution or provisions of Indian Constitution. So you can use ordinance making power to amend any law made by parliament, but you cannot use ordinance making power to amend provisions of constitution, because the logic is आप ऑर्डिनेंस प्रोमलगेट कर रहे हैं ऑन द एडवाइस ऑफ whom? यूनियन काउंसिल ऑफ मिनिस्टर. And Union Council of Ministers is there because what kind of majority they are enjoying? They are enjoying simple majority, or they are enjoying majority of more than 50% of members in Lok Sabha. So amendment के लिए what kind of majority we need? 2/3 of majority. So you are promulgating an ordinance on the advice of Union Council of Ministers, which is there, which is surviving on the basis of ordinary majority. But for amendment we need 2/3 of majority of member present and voting, that we have already discussed. So you can amend any ordinary law made by parliament, but you can through ordinance president can change any ordinary law made by parliament, but through an ordinance he cannot amend provisions of Indian Constitution. This is one important aspect that you people have to keep in your mind from examination point of view, कि ऑर्डिनेंस ला के किसी लॉ को अमेंड किया जा सकता है, बट कॉन्स्टिट्यूशनल पावर को अमेंड, कॉन्स्टिट्यूशनल प्रोविजंस को अमेंड नहीं किया जा सकता. दिस थिंग यू हैव टू कीप इन योर माइंड फ्रॉम एग्जामिनेशन पॉइंट ऑफ व्यू. एंड नाउ फ्रेंड्स, आई विल ट्राई टू डिस्कस विथ यू पीपल एग्जीक्यूटिव पावर्स ऑफ प्रेसिडेंट. एंड एग्जीक्यूटिव पावर्स ऑफ प्रेसिडेंट डिस्कस करने से पहले एक मैं आपको ट्रेडिशनल नोशन देता हूँ. जो ट्रेडिशनल नोशन है दैट इज in modern day democracy there are 3 organs of government: legislature, executive and judiciary. और जो theoretical या traditional notion है उसके according legislature they have responsibility to enact law, they have responsibility to design number of programs and schemes. Executive's responsibility is to execute these laws, to implement these programs and schemes. And judiciary is there besides performing other normal judicial function. Judiciary they validate or invalidate such laws on the basis of their constitutionality. These are the 3 functions that we have discussed while discussing theory of separation of power. That is a traditional notion among legislature, executive and judiciary, और ये इनके 3 functions हैं. But modern notion of executive power is much more than that. When I say much more than that, it means we can define legislative power, we can define judicial power, but whatever remains except legislative power, except judicial power, that is the power enjoyed by executive. So in Ram Javaya case and in Samsher Singh versus State of Punjab case, Supreme Court of India, they tried to define that what are those powers that will come under category of executive power, and in general it means carrying on day-to-day administration of country, formulating defense policy, security policy, monetary policy, external affair policy of country. So all such things they come under category of executive power. और हमने आपके साथ डिस्कस किया आर्टिकल 53, जहाँ पे आर्टिकल 53 was saying that executive powers at union level they are vested with President of India. So all treaties are concluded in his name, delegations are sent in his name, appointment of major constitutional dignitaries are made by him. So these are number of executive power. So on your screen you may see that Prime Minister and other council of member of other council of minister, Attorney General, Controller and Auditor General, Chairman and members of Union Public Service Commission, Governors of State, Chief Election Commissioner and other election commissioners, then Finance Commission, all these things, their appointment is made by President of India. So these come under executive power of President. Then under Article 78, later on also I will discuss while discussing position of Prime Minister. President may seek any information from Council of Minister, what kind of the proposals for legislations that they are about to present, what kind of the policies are being formulated, such kind of informations he may seek from Council of Minister headed by Prime Minister. It is the President who administers these union territories through the officers subordinate to him. In certain union territories where legislative assemblies are there, you may find Lieutenant Governor. In certain union territories where legislative assemblies are not there, you may find administrator, and with the help of these officials, President administers these union territories. Then he may appoint commissions related to a backward section of society like scheduled caste, scheduled tribe, other backward classes. So time to time, just to verify what kind of the improvement in their social and economic condition, educational condition has taken place, from time to time President may appoint such commissions to look into conditions of these backward section of societies. So that is another executive power of President. Along with such executive powers, President of India also enjoys some important financial powers. So while discussing financial powers, later on we will discuss legislative procedures. Again we will discuss these article 112, 110. But for your understanding, I am saying that it is the responsibility of the President that annual financial statement should be laid down before Parliament, जिसको आप जनरल इंटरेक्शन में बजट बोलते हैं. So annual financial statement, receipt and expenditure, उससे related जो statement है that should be laid down before Parliament. That is one such power of President under Article 112. Money bill can be introduced in Lok Sabha. So money bill is one special kind of bill जो कि केवल लोक सभा में इंट्रोड्यूस हो सकता है. It cannot be introduced in राज्य सभा. So money bill can be introduced in Lok Sabha only with recommendation of what? President. That is another financial power of President. Then later on we will discuss Article 265, 266, 267 in detail. But यहाँ पे मैं आपको बता रहा हूँ कि there is one fund known as contingency fund of India placed at the disposal of President. किसी unforeseen circumstances को, किसी unplanned expenditure को tackle करने के लिए immediately President can make advances from such contingency fund, generally on the advice of Council of Minister, and there is an upper limit of this fund like 500 crore rupees. So money like अभी कोरोना क्राइसिस चल रहा है और हो सकता है कि गवर्नमेंट को इमीडिएटली पैसों की जरूरत पड़ जाए. सो फ्रॉम कंटिजेंसी फंड such advances can be made which is placed at the disposal of President when there will be session of Parliament. Then with parliamentary approval more money can be spent from consolidated fund of India, and even this amount of money will be shifted from consolidated fund to contingency fund. These funds we will discuss later on while discussing legislative procedures, Article 265, 266, 267. But for the time being I am saying that is another financial power of what? present, where president can make advances from contingency fund to take care of certain unforeseen expenditure, then no demand for grant can be made except on his recommendation. So बिना प्रेसिडेंट की रिकमेंडेशन के मिनिस्ट्री से रिलेटेड जो भी प्रपोजल्स हैं, जो भी डिमांड फॉर ग्रांट है, कैन नॉट बी मेड. दैट इज अनदर financial power of president. So we discuss veto power, we discuss ordinance making power, we discuss executive power of president, and we discuss with you that is financial powers of president. And now one important thing, particularly from this year's prelims perspective, I am repeatedly saying judicial power of president, where president enjoys certain judicial power. He can appoint, he appoints judges of Supreme Court and High Court. In case of Supreme Court, appointment as well as oath, that is the responsibility of president. So president appoints judges of Supreme Court and he administers oath of office to judges of Supreme Court, theoretically, but in practically, among all judges of Supreme Court, he personally administers oath of office to CJI. Then other judges को personally administer कराते हैं CJI as per power delegated on him by President of India. But Supreme Court के judges का appointment and oath, that is one judicial power of President. High Court के judges का appointment, that is judicial power of President. Oath is administered by governors of state. This thing you have to keep in your mind. ये थोड़ा thin line difference है कि President appoints both judges of Supreme Court as well as High Court. सुप्रीम कोर्ट के जजेस की जो ओथ एडमिनिस्टर हो रही है दैट इज थ्रू प्रेसिडेंट. हाई कोर्ट के जजेस की जो ओथ एडमिनिस्टर हो रही है दैट इज थ्रू गवर्नर्स ऑफ स्टेट. पर्सनली प्रेसिडेंट एडमिनिस्टर्स ओथ ऑफ ऑफिस टू CJI. देन CJI इन टर्न एडमिनिस्टर्स ओथ ऑफ ऑफिस टू अदर जजेस ऑफ सुप्रीम कोर्ट एज पर पावर डेलीगेटेड अपॉन हिम बाई प्रेसिडेंट ऑफ इंडिया. देन अंडर आर्टिकल 143 presidential references can be made. So president may seek advice of Supreme Court on any matter which is related to a particular law. Any constitutional angle is there in that particular law. Just in order to see these things, president may seek advice of what? Supreme Court. And once such presidential references are made, then Supreme Court of India has to constitute a constitutional bench. A constitutional bench means a bench of minimum 5 judges of Supreme Court. Such bench should be formed by a Supreme Court, even though such advices of Supreme Court may not be binding on President. So that is one jurisdiction, that is advisory jurisdiction. Later on when we will discuss Supreme Court, again we will discuss this thing in detail. But ये एक judicial power है President of India की. Then under Article 72, President has certain clemency power, where he has power to grant pardon, reprieve, respite, or remission for those who got convicted in certain cases. Either he may absolve conviction as such, or he may reduce the amount of sentence. These are the varieties of the powers which is enjoyed by President of India under Article 72. But mind it, this power of President that is being exercised under Article 72, that is not as such judicial act, because such accused, such convict, he has already gone through judicial process. So this power, clemency power of President, is an act of grace. It is an act of executive grace, where President is going by some humane consideration, humane perspective. A legal angle has been already checked by judiciary. So judiciary has some compulsions, particularly legal compulsions, and judiciary, even though there might be some human angle, they may not take into that consideration, but such things might be considered by a person who is enjoying king like position, that is President of India. So clemency power or mercy power of President, or later on we will discuss in case of governor also, it is an act of what? Executive grace. So for your understanding, I made this kind of table कि कोई भी पिटीशन आपकी किस किस स्टेजेस से होके जाती है. तो यू विल फाइंड सेशन कोर्ट इन एवरी डिस्ट्रिक्ट, where session court they delivered judgment on any such appeal of victim, and if person was convicted by session court and if is not satisfied, वो अपील कर सकता है हाई कोर्ट में. If he is not satisfied with the judgment of high court, he may go to supreme court. सुप्रीम कोर्ट के जजमेंट को भी वो रिव्यू पिटीशन के थ्रू, सुप्रीम कोर्ट में भी रिव्यू पिटीशन लगा सकते हैं जिसके थ्रू सुप्रीम कोर्ट के जजेस अपने ही जजमेंट को रिव्यू करेंगे. एंड आफ्टर सच रिव्यू पिटीशन, even if you are not satisfied, then you may go for curative petition. But I am saying curative petition is not a right of an accused, a convict. That is a discretion of Supreme Court to either accept or reject such curative petition. Then he may also file mercy petition before president or governor, and at the last stage, if mercy petition has been disposed of, again he may approach Supreme Court that presidential consideration was not reasonable, there was some arbitrariness. So ये सारे stages हैं जो आप use कर सकते हैं. So after your appeal got disposed by Supreme Court, directly you may also file mercy petition. This thing you have to keep in your mind. But ये table, ये chart I prepared just to give you an understanding कि किन किन stages से आपकी पिटीशन जा सकती है मैक्सिमम अंडर इंडियन जुडिशियल सिस्टम, वेर इट प्रोवाइड्स मैक्सिमम अपॉर्चुनिटी टू ए कन्विक्ट जस्ट टू करेक्ट एनी मिस कैरिएज ऑफ जस्टिस. अगर कोई मिस कैरिएज ऑफ जस्टिस आपको लगता है कि हो गया है, तो इंडियन कॉन्स्टिट्यूशन में ये सारे प्रोविजंस हैं जिसके थ्रू हम बेस्ट पॉसिबल मैनर में आपको फेयर ट्रायल देने की कोशिश करते हैं. एंड वी ट्राई टू मेक श्योर दैट नो सच मिस कैरिएज ऑफ जस्टिस टेक्स प्लेस. President under Article 72 enjoys such kind of power. Pardon is the most important aspect, where President completely absolves the person from conviction as well as sentence. So as if no FIR was filed against you, आपका पूरा record is gone. So your entire criminal record is gone if President has pardoned you. If President has pardoned any convict, a person who got convicted by judiciary, so now he may walk like a free man. अब कोई आपका रिकॉर्ड नहीं होगा, कोई क्रिमिनल रिकॉर्ड नहीं है, क्योंकि आपका कन्विक्शन और एज वेल एज सेंटेंस दोनों को एब्जॉल्व कर दिया गया है. इस बात को समझने की कोशिश करिएगा. कन्विक्शन मीन्स जुडिशरी हैज फाउंड चार्जेस एस्टैब्लिश्ड अगेंस्ट यू, यू गॉट कन्विक्टेड, और उसके बेसिस पे वो आपको सेंटेंस देते हैं. तो यहाँ पे केवल सेंटेंस को नहीं हटाया जा रहा है, आपके कन्विक्शन को भी एब्जॉल्व कर दिया जा रहा है. एंड नाउ यू आर एज गुड एज ए पर्सन हु हैज नॉट कमिटेड एनी क्राइम. कम्यूट में क्या हो रहा है, वी आर जस्ट चेंजिंग कैरेक्टर ऑफ पनिशमेंट. सो प्रेजेंट इज चेंजिंग द कैरेक्टर ऑफ पनिशमेंट मीन्स इफ यू हैव बीन अवॉर्डेड डेथ सेंटेंस, इट गॉट चेंज टू रिगरस imprisonment, and if you got rigorous imprisonment, it got changed to simple punishment. So changing character of punishment, that you have to keep in mind, that is commute. केवल पनिशमेंट के कैरेक्टर को चेंज किया जा रहा है. रिमिशन में विदाउट चेंजिंग द नेचर ऑफ पनिशमेंट, अमाउंट ऑफ पनिशमेंट को रिड्यूस किया जा रहा है. लाइक 20 years रिगरस इम्प्रिजनमेंट को यू आर रिड्यूसिंग इट टू 10 year और 5 year ऑफ रिगरस इम्प्रिजनमेंट. नेचर ऑफ पनिशमेंट, कैरेक्टर ऑफ पनिशमेंट वी हैव नॉट चेंज, वी आर जस्ट रिड्यूसिंग द अमाउंट ऑफ what पनिशमेंट, ड्यूरेशन ऑफ पनिशमेंट, in respite reducing degree of punishment on some specific ground. like कोई अगर old man है, disease person है, कोई pregnant lady है, इन सारे human consideration पे degree of punishment को reduce किया जा रहा है. and in reprieve we are just trying to give some temporary stay on execution. like suppose if a girl, if a lady is pregnant, so if she will be executed, two bodies will die, that lady as well as the child that is in the womb of that lady. So here you may stay execution for 6 months, 7 months, 8 months, and we will try to make sure that new life should not get punished under this process. So that is the reprieve. So pardon, commute, remit, respite and reprieve, इनको लेके आपके माइंड में क्लैरिटी होनी चाहिए. UPSC they may ask, or some other state commission they may ask questions related to these 5 terms and what is their exact meaning. So this thing you should keep in your mind after discussing this judicial power. I'm just trying to make you remind certain important fact. Death sentences के cases में only president can pardon. Governor cannot pardon death sentence. That is one thing, even though that death sentence was delivered as per any state law. So that thing you have to keep in your mind. Perhaps it is not mentioned here that in case of death sentence, only president can pardon, governor cannot pardon. In court martial cases, president only alone has right. President only has right to give you any concession. Presidential power to grant concession is under union law. In case of state law also, if you have been delivered death sentence, only president can pardon it, governor cannot pardon it. कोई टाइम लिमिट नहीं है, कोई हियरिंग आपको नहीं दी जाएगी, जो हमने आपके साथ जस्ट अभी डिस्कस किया कि ये जुडिशियल एक्ट नहीं है कि वहाँ पे प्रॉपर हियरिंग होगी और प्रेसिडेंट जज की तरह बैठेंगे. नो सच प्रोसेस विल टेक प्लेस. ये एक तरह का डिस्क्रिशन है, बट इज़ नॉट दैट काइंड ऑफ डिस्क्रिशन कि प्रेसिडेंट हिमसेल्फ इज डूइंग दैट थिंग. वॉट एवर ही इज डूइंग ऑन द एडवाइस ऑफ काउंसिल ऑफ मिनिस्टर. सो इट इज़ नॉट डिस्क्रिशनरी पावर ऑफ प्रेसिडेंट. It is discretionary in the context, means it is not your right to have some hearing from president. So in that context I am saying it is discretionary power, but not discretionary power in that context that president is using this power in his own mind. He is doing it on the advice of council of minister, particularly ministry of home affair, जिनके पास उस convict से related सारा डाटा, सारी फाइल अवेलेबल है. No reason will be given. If president decides to reject your petition, no explanation, no reason will be given, but judiciary can review this power on the ground that some unreasonable arbitrariness element was there when president dispensed of such mercy petition of that accused or convict. Judiciary can review. Then military powers of president, where president act as a supreme commander of armed forces, and as a supreme commander of armed forces he has power to declare war, peace or conclude treaties, but mind it, on the advice of union council of minister. And it is the president who appoints chief of all three wings of our military, that is army, air force and navy. One another aspect is that emergency power of president. That I will discuss with you people when I will discuss emergency provisions that is separately mentioned in Indian Constitution. So with this I will wrap up my lecture on president. In 2 sessions I took this thing. Since it is a crash course, I tried to provide you maximum information, better understanding I tried to provide you, जिसके साथ आप एग्जाम में जा सकते हैं. And I tried to cover almost all aspect concerning president of India. From prelims point of view, from mains point of view, there might be certain aspects that later on we will cover, but from prelims point of view I tried to cover almost all aspects. So thank you to all of you. Thank you for listening me. In next class I will again come with prime minister and council of minister. So till that time you should revise it, and if you have any doubt related with this particular topic, you